the presumption is precisely, in the absence of evidence to the contrary, the courts will presume that mechanical instruments were in order at the material time. And the Law Commission specifically states in their paper that mechanical instruments include computers, which of course are not mechanical instruments. Now, I know a senior Crown prosecutor, who I will not name, who is now retired and doing similar things now, but in a different capacity, who said to me years ago, well, we know that it's not correct, but it's very convenient for us as prosecutors to have it. It saves us a lot of time. Barristers who specialise in defence in criminal work really know anything about electronic evidence at all. And they said, yes, that's correct. And that also suits us as well. We're very glad of the ignorance of barristers, because that allows us to get a lot more information in than we otherwise would do so. So that, first of all, it should not be for the defence to raise the issue there's something wrong with this computer.
No.
And have to prove it. And unless judges are more willing to order disclosure, then there is going to be more of the same that we find from the Post Office Horizon scandal, is that the vast majority of lawyers are not interested at all in the topic. You don't have to learn a lot about IT to understand the complexities of it. All you need to do really is have a vague idea, so you know how to ask the right questions of people when it comes to trial. You're going to find I'm going to put my finger on the screen occasionally, because this is a good example of the failure of software to tell you people actually believe what software tells them. And I have a smartphone which I'm using right now, which was is now a smartphone 6 SI, which was given to me by the Dubai Prosecution Authority for giving a talk a few years ago there. And there is no chip in it that has a telephone number attached to it. So Apple persistently have a piece of software which reminds me there is no chip in it, but they and therefore there's no telephone number associated with this smartphone. Now, the message actually is factually incorrect, because it talks about a malfunction when there is no malfunction. There is simply no chip in it with a telephone number attached to this particular smartphone. Now, when you think about the way people behave with computers, that's a good example of the inaccuracies that people assume are actually accurate. But to go back to the point about electronic evidence, when I first researched electronic evidence, I did think I'd better research all the case law where electronic evidence featured, and up until about 2007, actually, there were not many cases. And I had tangentially talked about this issue of evidence and electronic evidence in particular in a paragraph or two, not much more than that. But I then represented Mr. Job against Halifax Bank in 2007 or 2009, pro bono, through the free representation room unit, the bar FRU. And he claimed that some £2,000 was taken out of his account by ATMs, and I represented him on this case. And it occurred to me that the judge would use this presumption against my client. It was his case, he had to prove his case, and we had very little evidence from the bank. The bank were essentially relying on what little evidence they produced without any further disclosure. By the time I took on the case, some 18 months after he initiated it, disclosure had come and gone. And although in theory I could have asked for further disclosure quite late in the day, I took the view that a judge would not be very sympathetic to that, and would, if they did order disclosure, would order my client to pay the costs, which of course would not be possible. So we basically litigated the case on the basis of what evidence there was. And very interestingly, the judge did accept the possibility that actually computers are not reliable. And he agreed for me to publish judgment, which is actually published in the Digital Evidence and Electronic Signature Law Review. But that alerted me to the fact that this was actually quite a serious issue. And so I spent about 12 months researching not the law, but the technical side. And what I came to realize is that actually computers were far from reliable in the way that lawyers assert they are. And that's what led to the, in 2010, the second edition of the book, including a chapter on this presumption, which has been subsequently expanded and improved between the second and fifth editions. So that's where we are. Of course, once I read the Law Commission report, which I was not aware of in any great detail, it was a revelation to me. So I'm not suggesting that lawyers should have been highly alert to this in 1997 when it was being discussed by a Law Commission, because it was not really on most people's horizon. And the internet, although 10 to 15, maybe 20 years old by then, was still not actually in general use. Although a lot of evidence in electronic form was being adduced, nevertheless, of course, it was proving to be a problem by the time that Law Commission wrote their report in 1997. So that's how the book that's how the book came about, but also how the chapter on the presumption came about as well. So in the chapter, I aim basically to establish the evidence to the contrary that the Law Commission's presumption is not correct. That's the sole reason for doing the chapter.
And just to recap what the presumption is.
The presumption is precisely, in the absence of evidence to the contrary, the courts will presume that mechanical instruments were in order at the material time. And the Law Commission specifically states in their paper that mechanical instruments include computers, which of course are not mechanical instruments. So that's the presumption. And Section 69 of the Police and Criminal Evidence Act 1984 was duly abolished, repealed rather. And there's both a statutory presumption now and a common law presumption as well.
So the end result is that courts have happily assumed that computer evidence is reliable, and it's up to the claimant to prove otherwise.
Yes, that in essence is what has happened. Although, as my co-editor Daniel Seng, Professor Seng from National University of Singapore, keeps on reminding me, is that it is only an evidential burden, but that is not the point. It's been treated very much like it's a fact, and the Post Office Horizon scandal, in particular, the case of Seema Misra, demonstrates how it was used in courts up until recently. Well, I don't know quite, having now retired, how it's now being addressed in courts. Certainly in criminal trials, but if I can, what I will do is I will look at the nub of this. Comes really from the Law Commission report, and paragraph 13.23, which does bear repeating, and I'll repeat that now. And they say, our recommendation: we are satisfied that Section 69 serves no useful purpose. We are not aware of any difficulties encountered in those jurisdictions that have no equivalent, which is fine. Although what they don't look at is how those jurisdictions actually deal with electronic evidence, but that's by the by. We are satisfied that the presumption of proper functioning would apply to computers, thus throwing an evidential burden onto the opposing party. Now, the problem with that particular sentence is that they don't present any evidence in the paper to demonstrate the truthfulness of that statement. which of course is what I later researched and demonstrated it was not correct. Interestingly, Professor Stephen Murdoch of University College London has decided to look at some at the papers that were presented to the Law Commission and also their responses. And one response under the Freedom of Information Act, and one response from the Crown Prosecution Service essentially says, well, we know there's a bit of a problem with computers here, but we actually would prefer to get rid of this requirement under Section 69, which is fairly onerous and actually impossible to deal with anyway, and we can look at that in a moment. But they said, please go ahead. We'd be delighted if you have this presumption of reliability. Now, I know a senior Crown prosecutor who I will not name, who is now retired and doing similar things now, but in a different capacity, who said to me years ago, well, we know that it's not correct, but it's very convenient for us as prosecutors to have it. It saves us a lot of time. And in combination with that, they also said, in my response, it doesn't seem to me that many barristers who specialise in defence in criminal work really know anything about electronic evidence at all. And they said, yes, that's correct. And that also suits us as well. We're very glad of the ignorance of barristers because that allows us to get a lot more information in than we otherwise would do so. So that does illustrate the point that I've been trying to make at least since 2010, that electronic evidence ought to be a compulsory part of being a barrister or a solicitor. But I'll go on now with the with this quote from paragraph 13.23, because it is quite important. It goes on to say, I'll repeat it, we are satisfied that the presumption of proper function would apply to computers, thus throwing an evidential burden onto the opposing party. But that burden would be interpreted in such a way as to ensure that the presumption did not result in a conviction merely because the defence had failed to adduce evidence of malfunction which it was in no position to adduce. We believe, as did the vast majority of respondents, that such a regime would work fairly. Well, as the Post Office Horizon scandal has finally established, all of that is not correct. First of all, it should not be for the defence to raise the issue there's something wrong with this computer,
No.
And have to prove it, which is implied by that particular comment. And the fact that they say that a regime would work fairly is clearly not the case either. So if we consider the case of Seema Misra from 2010, in that case, and I published the entire transcripts of the trial. Fortunately for both her and I think most other people, I applied to the judge to buy the transcript shortly before it was actually under the rule to be destroyed because it was no longer needed. And I got his permission to publish, and I also got Seema Misra's permission to publish, because clearly it was a very drastic thing for her in her life and had a lot of effect on her life. And her life was going to be exposed by us publishing the transcript of this trial. But nevertheless, what the transcript of the trial demonstrated, amongst other things, is that actually the defence had tried on 4 separate occasions to ask the judge for further disclosure, which the Post Office refused to give up, and the judges agreed with the Post Office. In each of those cases, quite clearly, both at the time but also subsequently, it's demonstrated the judges were wrong not to order further disclosure. So the electronic evidence is closely linked to the disclosure, the proper disclosure. And the point about electronic evidence is that invariably it's not in our possession. It's not in the possession of defence. If the Crown Prosecution Service are going to be using electronic evidence, it's not in their possession. If you take evidence from the cloud, by way of example, it's actually in the possession of maybe more than one organisation. And so the whole range of issues that come out of this, including obviously its authenticity and its provenance and all the rest of it, all of which affect its reliability. But that's where the Law Commission, I think, fails significantly.
And that's more or less where we're at now, isn't it? With a list of problems about who knows the answers and where are they and who owns the information. And
those are part of the problems, yes. But I think the significant problem now with this presumption of reliability is that the Court of Appeal did not deal with that particular issue in the appeal, the first appeal, with the 40-odd applicants from as a result of the post office trial, the civil litigation. That's partly because the barristers in the case did not argue this point, but also the court itself did not bring up this point on its own volition, which is very disappointing. So in essence, this subject and this presumption has actually had no judicial input at all, which is extremely disappointing. So at the moment, we're in a position whereby it still exists, but whether or not judges are actually allowing it to go ahead and be used by both the prosecution is debatable. I just don't know.
How do you understand that position by the judiciary? How do you understand that unwillingness to grapple with it?
I must admit, one can speculate. One of the problems I came across and have come across in sort of 20 years of doing talks about this is that the vast majority of lawyers are not interested at all in the topic. Quite interestingly, European lawyers are, but English lawyers aren't. I've done only one or two lectures in the UK and Scotland and England, very poorly attended. I've done a lot of teaching of this subject to judges and lawyers in Europe through the Academy of European Law based in Trier in Germany. And of those courses, I once had a judge from Northern Ireland on one course and once had two judges from England on another. But apart from that, nobody other than the members of the DPP from the Republic of Ireland have ever attended from common law countries. This is quite interesting because when you speak to European lawyers from basically a civil law jurisdiction or from the Nordic countries that have a similar evidential position as we have in the UK, but without hearsay, none of them have textbooks on evidence. They think the common law textbooks on evidence are really quite weird, but they're all incredibly they all consider this topic to be incredibly important. Now, what is also quite interesting in my discussions with European lawyers is that although there is no presumption that computers are reliable in European jurisdictions explicitly, apparently there is implicitly when it comes to judicial reviews. So there's a combination here of the refusal to understand that actually we have now changed the way that we look at evidence. You cannot look at electronic evidence in the same way as you would look at evidence based on paper or on a stone or in a photograph or anything like that. There's an inherent refusal of lawyers across the world not to be involved with electronic evidence if they can. I once spoke to a German lawyer who said they had a partner in their law firm who had about 7 years to go before he retired, and he did everything in his power to avoid anything to do with electronic evidence. And I'm sure that's the case, not just in Germany, but across the globe. And this is not satisfactory because although you don't have to know anything about the technicalities of software and how it works, you just need to know the questions to ask, and you just need to have a very broad understanding of the subject, which is the purpose of our book on electronic evidence. Obviously, it just gives you a brief introduction. It doesn't give you any detailed technical knowledge at all, but that seems to be seriously lacking in the three jurisdictions in the United Kingdom, and nobody has taken up the challenge that we laid down in 2010 and also in 2013 of actually introducing compulsory CPD points in electronic evidence. So, for instance, in 2013, I published 2 articles, one by a Singapore lawyer and one by an English academic. And I posed the same question to both. And I said, do you think that electronic evidence ought to be taught to lawyers? I have a view, but I'm interested in your view, please. And they both wrote essays, which we published in 2013, and they both agreed that it should be taught. Now, Denise Wong, in her essay, pointed out that it really should be part of a university course, whereas Deverell Capps, in his article, said, well, the syllabus is so full for a university course, and it's also very little time in the professional vocation. In addition to which, he said, look, there are so many people who go to university who do a law degree without intending to be lawyers, so why should they be bothered about learning this subject, which is fair enough. And he's also, when you look at the dropout rate for vocational courses, there's no point in teaching everybody this on a vocational course. So the appropriate time, he thought, was to be post-vocational course compulsory CPD, which could be done over 3 or 6 hours. And actually, I think that is the most appropriate way of dealing with it, really, because it doesn't have to be in depth. But nobody, absolutely nobody, has taken this on at all. And when I was a member of the IT panel of the Bar of England and Wales between 2000 and 2018, I persuaded my colleagues on the IT panel that this was an important subject, and my colleagues were convinced, and the chair would, when the Bar Standards Committee, the Bar Standards Board, asked for comments about revising syllabus, would put this forward, and it's been routinely ignored. I mean, in addition to which, the presumption itself, the Institute of Advanced Legal Studies, of which I am honoured to be a research fellow at, some years ago now, I think in 2011 or 2012, put forward a suggestion they ought to start a think tank. And they suggested that we ought to put forward suggestions for changing the law. So I put forward a suggestion that we might ask the Law Commission to revise this presumption on evidence and computers. And they agreed, so we duly put it to the Law Commission, and the Law Commission dismissed it, which is, really, I was obviously quite shocked and disappointed. But there doesn't seem to be any move by anybody, either from the Law Commission or from the government, to change this, which is really quite startling.
It does seem extraordinary, though, bearing in mind the huge number of miscarriages of justice, Stephen. I mean, I don't understand how you can think about the two things and not join them together and say, we have to do something about this.
Yes, I agree. But don't just focus on the Post Office Horizon scandal. Think about the things that you do every day. Think about the number of transactions that our banks do daily. Think about, you just have to look at the Saturday newspapers where people have problems with their banks and they eventually have to go to a journalist to get remedy. Banks also, either explicitly or by implication, rely on this presumption to prevent their customers from receiving a return of the money that's been taken out of their account. And that's on a gigantic scale. And this happens every day. So this is not just the post office. No. This actually is on a very wide spectrum.
I mean, I feel terrible to think that you have spoken to prosecutors who seem to not care whether people are guilty or innocent. They've just got a case. And I've spoken to quite a number of sub postmasters and mistresses who say that's what they genuinely believe, that the barristers believe this is a game that they have to win, and it is not about looking for the truth. And that's what you've said seems to support that.
Well, what supports it is if you look carefully at the transcript of the trial of Seema Misra. The prosecution barrister seems, by the comments they made, which is on record, to think that's precisely the point of the prosecution. I'm not going to voice an opinion as to what I think on this subject, because it would be misconceived of me to do so, because I don't know enough people in the prosecution service to know whether or not any views I may or may not have. And actually, to be perfectly frank, I don't really have any views on this. Until you mentioned it, I hadn't thought that the Post Office Horizon case might be the only one that exhibits this as a problem. That shows you my insular thinking as much as anything. But when I was at the bar, in the criminal bar, a long time ago, clearly there were barristers who only saw it as a fight for them to win, regardless of what the justice of the situation was. That may still be the case in certain circumstances. I do not know. But if you look at the litigation over the post office scandal and the phenomenal number of times that the post office appealed every single thing on appeal, then you realize, first of all, the decision-making process of spending money from the post office point of view, but also the willingness of barristers to take the fees and argue pointless arguments before Court of Appeal, which they probably knew they would lose. And to be fair to the barristers who represent the post office, they probably told the post office, look, you're going to lose this completely. I mean, I'll argue the points, but you have to understand that you're going to lose this case. And I'm sure that sort of advice was being given to the post office. I'll be surprised otherwise.
But I think the argument was, well, we drive them with costs and they'll have to give up because the backers will pull out. So we go for it anyway.
That was the argument, and it was done by pushed by a particular person within the post office. I understand, but I'm not at liberty to say who it was, because it's not in writing anywhere and it's not been written down. It may come out in evidence in due course.
Yes, but one of the things I think you've suggested is that there is in fact some information which people could share about their computer system, which would help a defence anyway, in terms of, for example, revealing the error logs, for example, and various other fairly standard bits of information which should be provided simply to confirm that a system is reliable or reveal where it's not reliable.
Well, actually, let's forget about reliability. No computer is reliable. As you discovered today with trying to connect with Zoom, you've had to do it twice. Reliability actually is irrelevant. It's actually a massive red herring. Paul Marshall, who you will know as a barrister, represented Seema Misra and would have done so at the Court of Appeal hearing, but for reasons we won't go into, didn't. He contacted then the then Minister of Justice and said, look, we've got to do something about this. We've got to persuade the judges that they've got to have a better framework in place to deal with this. And that caused him to gather together others, including myself, but all the technical people, to write a paper with recommendations, which I published in 2001 on the probity of computer evidence. And we've set out a two-stage process there, which actually is very easy to follow. And it's not one of the things about disclosure that those being asked to disclose constantly use the argument, well, it's going to be very expensive. When we have demonstrated in that paper that actually the sorts of things that could tell us more about the system, where the evidence is coming from, is not expensive to provide if you are running a well-maintained system. And of course, if you're not running a well-maintained system and you cannot produce the evidence, then the suspicion is there is something seriously wrong with the system. And if that had been adduced, let's say in the Seema Misra case in 2010, I'm sure the outcome would have been much, much more different. And there's also Dr. Stephen Castell, who wrote a paper called The Appeal Reports way back in 1987 or thereabouts, which is cited in our book. Stephen actually set out a load of criteria way back in the 1980s to deal with electronic evidence. And the Law Commission did not even mention this in their 1997 paper. So there were no caveats. There was quite a simple assertion: computers are reliable, therefore let's go ahead with it, without the sort of caveats that Stephen Castell had introduced way back in the mid to late 80s, and that is quite a shock as well when you actually look at it in perspective.
Do you think that the kinds of things that you've listed as being reasonable information that a system should be able to produce, do you think those things are changing as time goes by because the technology changes, or do you think they
Yes.
remain reasonably the same?
I'm sure it's one of those sorts of things that you will have to keep on updating on a regular basis as the technology changes. I'm sure that will be the case. So several years ago, I was asked, I think when I was in Budapest at an event run by the Academy of European Law, whether there was a convention on electronic evidence. I've been asked it several times in the previous years, and I said there hadn't been, but maybe we ought to write one. And that's what we did. In 2016, we published a draft convention on electronic evidence, which has not been taken up by anybody so far. But the point about that draft convention is that it's only version 1. And in fact, next year I'm going to propose to all my technical professors that perhaps we actually conduct a revision of that and maybe publish version 2 in 2023. And the whole point about computers is that they are dynamic, they're not static. So we have to actually bear that in mind. And the problem is, at the moment, people don't seem to appreciate that is a significant issue.
One of the most frightening things you're talking about is that all of us are dependent on computer systems now, which we have no control over and which are impenetrably complex. And we have very little prospect of being able to defend ourselves if the owners of those systems or the operators of those systems choose to deny us any information about what's gone wrong. And the judiciary aren't going to make any effort to protect us.
This is the problem. I wrote a paper in 2017 about this very issue. It was based on artificial intelligence and software, but nevertheless it applies to the world in which we live now. And my argument was that it's the judges and the lawyers that are now central to the world in which we live. And unless judges are more willing to order disclosure, then there is going to be more of the same that we find from the Post Office Horizon scandal. That they are now the keepers of the world in which we live. And it's incumbent on judges to use their very important powers of disclosure to order up disclosure. And what is quite interesting is that when somebody is ordered to disclose something which they know is going to actually reveal the weaknesses in their systems, very quickly you discover them entering into an agreement to cease litigation and just withdraw from the process. But the problem is, this is just my personal opinion, but it seems to me that judges almost think that when they order disclosure where one party says it's very expensive, that it's almost as if the judge is paying for that money out of their own pocket themselves, which is not the case. No. So there's a very famous case from New York, I think in about 2005 or thereabouts, I can't remember the precise dates, the Zuber Lake case. It's where a lady by the name of Zuber Lake alleged that she had been discriminated against with a bank. I can't remember which bank at the moment. And they have discovery in the United States, as you will know. And she wanted discovery of more email tapes than the bank were prepared to deliver up. So they had some preliminary arguments about this. And the judge in that case said, well, the bank is required to deliver up these tapes but Zuberlake will pay 25% of the costs of doing so. Now, the reason why the judge has said that is because the amount of damages and compensation that can be awarded in America is substantially more than in the UK. And so, of course, it would be worth the plaintiff to actually make that payment. And in this case, it was a very good judgment, in my view, because it did reveal a lot of incriminating emails that proved her case, and she actually won the case in the end. So it is not beyond the realms of possibility to get this right, in my view.
Sorry, I'm sorry to interrupt. Do you get the impression the Americans are ahead of us on this? Are they being more assertive about it, or is it the same problem?
They've only just becoming. They are now just becoming more assertive in the last 2 or 3 years.
Right.
There are judgments where judges have been saying, "Look, this is ridiculous. You can't argue the issue of costs and complexity here. This is essential evidence, and you will deliver it up." It is only just beginning to happen, though.
Yeah. Sorry.
Are we reaching the point, do you think, where actually, if you're a defendant in a case like this, that an expert is essential?
In most cases, yes. Let's take another example. It's in our book. I can't remember precisely the name of the case now, but virtually every car on the road that was built, certainly roughly from 2000 onwards, if not before, contains software code. There's not a car on the road that doesn't, unless it's a very old car and it's an antique. I have a car from 2002, but the engine management system is controlled by software code. The cars you buy now, almost everything is controlled by software code. Unnecessarily so in many ways. It's just overburdens the engine management system. In fact, there's more software code in motor cars than there is in commercial aircraft. Just think about that for a moment. More software in your little car than in a commercial aircraft that ferries 400 to 500 people across the world. Now, commercial aircraft software is very tightly controlled. It undergoes enormous amounts of regulation before it's accepted. And even then it goes wrong, as we know with the Boeing crashes.
Yeah.
In that case, software was doing what it was supposed to do, but it was doing it incorrectly, and caused loss of enormous amounts of lives. Now, it is not often reported the number of motor cars that take off to top speed without their owner pushing the pedal down. The software takes over the car and takes it to top speed. This happened in the case of Bookout in America, and it's one of the few cases that have been litigated through the civil courts. And although Toyota even today disagree with the agreement that they were liable, nevertheless they were found liable and had to pay compensation. It's happened in this country. It's happened in lots of other countries. Now, there was a case in this country where this occurred, and the problem is the software produces error codes, and the only organization that can tell you what that error code means is, of course, the manufacturer. Invariably, motor car manufacturers across the world do not have their own software houses. They obviously subcontract to others. And in this particular case, the only way I could get to roughly the truth of the evidence presented in the court, because it wasn't, it was just a trial, and so of course not reported, and you can't necessarily get all of the detail from journalistic reports. I actually corresponded with the expert in this particular case, and he said an expert came from the motor car manufacturer and just said that this particular code, which was an error code, which may or may not have helped determine the cause of the crash and therefore killing somebody, was not relevant. Now, that is totally unsatisfactory to say something is not relevant in a criminal trial where somebody has been killed. And the poor driver of this car is being held to account for something which perhaps they never did. So this illustrates the point that we do rely on many different third parties in our lives, and the point that you made earlier. And as far as I'm concerned, from an outside perspective, not as a lawyer, just as an ordinary person who takes part in life myself, this is not satisfactory. Software companies are not being held to account properly. And it's a significant problem globally, not just in this country relating to this particular issue. My knowledge about technology is zero, but I do know enough to know that we have to challenge it, even though we don't know how to challenge it. And that's where the search engines come in. But here I have a paragraph 1.39. 5.139. It follows that lay people are not aware of the inherent design faults and trust their personal experience to reassure themselves that computers are reliable machines. Yet lay users, and I include myself as a lay user, obviously, yet lay users regularly experience problems with devices, which illustrates their failure to grasp that reliability and software code are impossible to guarantee. And unfortunately, this is still prevalent throughout the legal sphere, and we've got to try and change that. It isn't actually, you don't have to learn a lot about IT to understand the complexities of it. All you need to do really is have a vague idea, so you know how to ask the right questions of people when it comes to trial.
Exactly.
And you need an expert, obviously, as well, to help you with that, because you don't know yourself.
So if I can mention Dr. Stephen Castell again, he was actually asked to represent a defendant in one of the early post office trials under the Horizon system way back in 1999. But first of all, they could not get legal aid, which is quite shocking, because that's another aspect of this problem from the point of view of the defense. If you've got no income or no money to be able to pay for this thing, if you're in civil litigation, then how are you going to actually challenge the other side? And in criminal matters, if you don't get legal aid to cover these costs, what are you going to do? How are you going to actually challenge the evidence? And in this particular instance, Stephen Castell is convinced that they would have exposed the Horizon system for what it was in 1999 had he been made an expert witness. But of course, no legal aid, so he couldn't represent the client.